So thank you everyone for joining us today, for taking time out of the busy summer schedules. But we just wanted to take, 20 to 30 minutes to get everyone up to speed on what's been going on in the case and get everyone the same information about what the class action is about. Some of you here today may have already spoken to us, and so some of this information might not be new, but we're also hoping that there are some new faces at today's webinar or who will be watching the recording in the future that will benefit from this information. So I'll just do a quick round of introductions on the Hollywood squares I have here. So we have Paul Miller from Howie Saxon Henry. We have Megan Hall also from Howie Saxon Henry. So myself, Paul, and Megan are here in Toronto. We have Jen Winstanley, who's a partner at Camp Fiorante, along with Sophie Moraldo, also at Camp Fiorante in Vancouver. And lastly, we have Elizabeth and Siobhan from the Branch McMaster law firm. Siobhan is here representing the Vancouver office, and Elizabeth is here representing the Toronto office. So I'm going to do a quick screen share here to our PowerPoint. So it obviously would not be a legal webinar without a few disclaimers, so please bear with me. This webinar is intended only for class members, and so to maintain confidentiality and privacy, we have disabled the Q&A function and the chat function. If you have any questions for us during the webinar, please email me directly. My email is there up on the screen. It's vlord@hshlawyers.com. And we'll try to get to your question at the end of the webinar. Otherwise, we can always shoot you an email back with the response or set up a call. We would also ask at this time if there's anyone representing the defendants or any members of the media that you please excuse yourself from the webinar, as again, this is intended to be a closed webinar for just the class members and their families. And also just a note that class actions are a very complex area of law, and this presentation is not meant to provide legal advice on any independent issues, and obviously the contents and the recordings should not be used without our permission. I've introduced the people here, but just a brief overview of who the law firms of Howie Sachs, Camp Fiorante, and Branch McMaster are. The three firms have had the pleasure on working on a number of cases together over the years and bring together a wealth of experience in mostly plaintiff class action litigation, as well as some insurance litigation, some government litigation. And so all the information is all up on our website. So I do encourage you, if you're looking for more information about who we are and what we do and why we are the lawyers representing the class members in this case, I would encourage you to take a look at our website. And so with those brief introductions, I'll pass it on to Megan Hall from my office, who's going to give you a brief overview of what the case is about. So with that, go ahead, Megan.
Thank you, Valerie. Hello, everybody. Thanks for joining us. We have heard from gymnasts from all across the country, from all ages, all levels of gymnastics, some who are still training and competing, and others who left the sport long ago. And as we speak with them to explain what we're doing, which we're doing today with you, we often hear stories, or at least parts of stories that you're comfortable sharing. And there are some common themes that we've noticed. And the sort of the predominant two, I think, to me are the fact that the experiences seem to be all too common, regardless of provincial boundaries or levels of competition, which is devastating, of course. But the second theme that I've noticed is really the deeply held love, commitment to the sport, passion to the sport, and the desire of gymnasts, young and old, not to give up on it, but to bring about change. And so that's how this proposed class action fits into the picture. It seeks to change the way that gymnastics athletes are treated and to recover compensation for athletes who suffer physical, sexual, and psychological abuse. The claim alleges that the defendants named in the lawsuit caused or contributed to the abuse of those athletes by creating a culture and an environment that allowed that abuse to to begin, to be fostered, and to continue. And by failing to take steps to protect the gymnasts under their care and their training. When we're considering who can participate in the proposed class action, which Val, do you mind switching to the next slide? This case has been filed in British Columbia, but that doesn't mean that only gymnasts in British Columbia can participate. It's national. It's anybody in Canada. It includes all gymnasts living in Canada who claim that they were abused while participating in Gymnastics Canada, provincial member associate organizations, or member club programs between 1978 to date. And I should mention here that the legal team does our best to take a trauma-informed approach. And when we say, people that claim they were abused, we see you, we hear you, we believe you. The proposed class action, or those that can participate, include all gymnasts who participate in activities or events run by Gymnastics Canada, by provincial member associate organizations, or member club programs, as I said. You'll hear a little bit more about the ins and outs of the class action process itself, and the definition may be subject to change as we seek court approval. Valerie, back to you.
I think I'm actually responsible for the next few slides, so I'll just dive right in. These slides discuss class actions generally. So on this slide and the next slide, we talk about the main steps that a class action will go through. So starting at the top of the slide there, we have a broad definition of what a class action is. All it means is that one person steps forward and says, I've experienced this wrongdoing. I think there are a lot of other people who've experienced the same wrongdoing, and I would like to bring a lawsuit on their behalf. So that's all a class action is. There's 9 main steps that a class action may go through. The first one is that the representative plaintiff files a notice of civil claim. So we've done that. That was filed on May 11th this year. And if anyone's interested, I think it's up on all of our websites if you wanted to take a closer look at that. The second main step is the certification hearing. What that means is that the court has to decide that the case can proceed as a class action rather than just an individual claim. And there's a legal test that we need to meet in order for the court to decide that we can go ahead as a class action. And that stage of the case is called the certification hearing. So that's the first big step, and it really dictates where the case goes. If the case isn't certified, we're left with an individual action and we need to decide what to do with that. If it is certified, we'll have whatever class definition has been certified, and we'll go forward with the rest of the steps that are set out on the slides here. So assuming that we do get certified, there will be an opt-out period. What that means is that anyone who falls within the class definition but decides they don't want to be involved in the class action, they will be given an opportunity to exclude themselves. Typically, that just means you send us an email or a letter, you give us a call, and you tell us that you give us your information and say you don't want to participate. Once that period has expired, that's called the opt-out period, we start with what's called the discovery phase of the litigation. So this is when we get documents from the defendants and we get the opportunity to ask questions from their representatives. So that's called an examination for discovery. On our side, we produce documents that we say are relevant to the case. This is typically limited to documents from the representative plaintiff in a class action. And the representative plaintiff will also be examined for discovery. So that means the lawyers for the defendants will sit down with the representative plaintiff and ask her questions about the lawsuit. Number 5 there is mediation. So at any point, if the parties decide that we want to go to a mediation, we can all have a meeting together and talk about whether we want to resolve the case through a settlement. So number 6 there, that's settlement. Again, that can happen at any time if all the parties sit down and we reach a solution that we all agree on. If we do reach a settlement in a class action, the court has to approve the settlement. So it can't just be that the lawyers decide, all agree that we should settle the case. We have to go to court and explain to the court why we say this is a good settlement. The test for that and what the court's going to be looking at is whether the settlement is in the best interest of the class members. When we do a settlement approval hearing, we also ask the court to approve any lawyer fees that we are requesting. And I don't see it on the slide there, but at the settlement approval hearing, so if we reach a settlement, we'll be sending a notice to everybody saying, here's the settlement. We think this is a good result for X, Y, and Z reason. But if there's a class member that gets that notice and says, you know what, I don't like this settlement, you do get an opportunity to object, and that's at the settlement approval hearing. If the settlement is approved, we would move on to what's called a claims administration process. And during that process, class members can make claims for a portion of the settlement funds. If no settlement is reached, the case moves forward to a trial on the common issues. So common issues are the questions that we say are common to all the class members and will move each of their claims forward. Those are decided at the certification hearing. So part of the certification order will include a list of all the common issues that the court has certified. So that's called the common issues trial. If we're successful at the common issues trial, and the claims are not fully resolved, so good chance here that they would not be fully resolved because there might be some individual damages issues that would need to be resolved after a common issues trial. Then we have some sort of an individual, it says on the slide there, an individual issues trials, but it can be any sort of process that the court approves to decide the individual issues. So it might not be an actual trial, it might be affidavits, it might be just whatever the court decides is a fair way to determine those remaining issues. Obviously at number 8, if we go to the common issues trial and we lose, then we're done there. So what it means for this case, in this case, Amelia Klein is the proposed representative plaintiff. She has put her hand up and stepped forward to represent all of the class members. Assuming we get to the certification hearing and the court certifies the class action, all class members, sorry, I shouldn't say all class members, but there will be all class members we've been in contact with. We will be sending a notice directly to you. But if we won't have contact information for all class members. So we do what's called a notice program and just publicize the fact of the certification of the action as widely as we can so that anyone who's affected can decide whether they want to participate or they want to opt out. Potential class members who do not want to opt out don't need to do anything at that time. If the case is certified and you meet the class definition, then you are a class member and you are included. When the action is resolved, so either by settlement or by a decision at trial, everyone in the class that is not opted out is bound by that resolution. And then there's a note here about the claims process. So funds from any settlement are typically distributed according to the category in which the person falls, and it can depend on a number of factors. So the claims process is another aspect that needs to be approved by the court. It's something that we would be drafting as law firms and getting input on. And we would present it to the court and say, we think this is a fair way to distribute the settlement funds, and the court would say yes or no. And then final note there, if a trial is required, class members may have to prove their individual losses after the common issues are determined. I talked a little bit about that on the previous slide, but that's just meant to highlight that for a lot of this process, class members have limited involvement or can choose to have limited involvement, but there may be a point during the claims period or at the individual issues phase of a trial where individual participation would be required. So what does it mean to be a class member? First of all, there's no cost to participate in the class action. Anyone who meets the class definition is automatically a class member once the class action is certified. And anonymity. So class member names are not part of the court record unless and until the individual claims stage. Just to clarify that a little bit, if it is a claims process that's arising from a settlement, the names may not need to be part of the court record. But I think the main point to make here is that if you're a class member and you're concerned about anonymity, that's something you can reach out to us about, and we can explain to you, when your name might need to become part of the court record and what we can do to keep your name not public if you are participating and you don't want your name to be made public. So, for example, if we think a class member has information that would be helpful for the certification hearing, we would contact you individually. We would say, we think your evidence would be helpful. Are you comfortable providing an affidavit? And if you are you comfortable having it be in your name or not? If you're not, that we may have options to file that evidence anonymously. And that's sort of the same as the case continues. If you're asked to provide evidence, there are steps that we can take to ask the court to protect your identity. And if that's something that's important to you, then we're happy to talk to you more about that if and when that situation arises.
Hi, everyone. So I'm going to continue speaking about what it means to be part of a class action. And so some of the benefits of a class action are, as Jen just said, that there's no cost to being a class member. So perhaps the biggest benefit is that there is no cost to participate as a class member in this proposed class action. There are no upfront legal costs. Class counsel are paid on a contingency fee basis from the proceeds of a settlement of a judgment. In other words, we get paid a certain percentage of any overall settlement or award at trial. If the action is successful, you may get compensation for your injuries without the need to start your own legal action. There is also the option to opt out if you do not wish to participate in this class action. Sharing your story with the lawyers does contribute to the case, but without the need for your name or information to be public. Another benefit to a class action is avoiding duplication of lawsuits and answering all questions at once. It then provides a simplified process to resolve any residual issues that may have to be individually looked at. So how long does a class action take? Class action lawsuits can take a long time to reach a final resolution, particularly if the defendants oppose certification and engage in delay tactics. Cases may take as much as 3 to 6 years, sometimes up to 10 years to complete. A number of different factors can impact this timeline, particularly the conduct of the defendants in the litigation and their willingness to reach a resolution. We expect that the certification hearing will be heard sometime in the next 1 to 2 years. If successful, it is possible that the defendants might appeal the decision, which would then cause a delay of up to another year before the case proceeds to the discovery phase. It is important to remember that this is not a class action until it is certified, and we are not yet at that point. This is often a mistake made by the media. So how much compensation will you get? It is possible that this case will not be successful, which is always something to keep in mind. However, if it does succeed, it is too early to tell the value of the case overall, as that will depend on how many class members there are and the extent of their injuries, and whether a settlement is reached or if each class member must establish her or his own losses. Factors that typically affect compensation include things such as how many class members make a claim to the settlement fund, what happened in each class member's individual circumstances, and the litigation risk. Any proposed compensation structure for class members must be approved by the court and it is the court's responsibility to ensure that any settlement is fair and reasonable for the class as a whole. So what do I need to do to participate? There is nothing further required from our class members at this time. However, there will come a time that you need to decide whether or not you would like to stay in this class or not. We encourage all potential class members to identify themselves to us and to provide details of their claim. This way we can communicate directly with you, and we can also aggregate your experience for the purposes of assessing the right amount of damages to claim in any settlement discussions. We will also send updates about the case via email and also post on all of the firm's websites. There will also be a direct notice according to court orders. So if you think that you have any information that may be useful to the case, or if you would like to speak to one of us lawyers to inquire as to if you would be a potential class member or not, you can contact us directly, or as you'll see on the next slide, we have a toll-free phone number you can call, a general email address you can email, and under that you'll see some of the lawyers' email addresses and phone numbers so you can call us directly. Val, I'll pass it back over to you.
Thanks, Liz, and thank you everyone else. I'll reshare those contact informations with the email that will come out afterwards with the recording. We'll probably get the recording finalized sometime this week, so take a look at that. I really do want to reiterate Liz's point about like how important and how much we are looking to speak to as many people as possible. There really is strength in numbers in this case, and we know from our experience with working with Amelia for over a year now just how difficult and how reluctant some people are still in coming forward, and we completely respect that and will respect anyone's decision if they choose not to. But even just letting us know that you would be potentially interested and just leaving your name and your contact information is already very helpful to us. Sharing this webinar once you get the link with other people who you might think might be interested in learning more is also really helpful, and just doing whatever you can in your community to make sure that people are getting access to the right information about the case. And that information does come directly from us. And we also don't want to burden class members with having to necessarily relay the information either. So I just wanted to reiterate just how important it is and how much we really are here for anyone who has questions or who wants to share their experience or not share their experience with us. That's totally up to you. So we'll close things off with a few questions that we did receive. I'll either open it up to the floor or pick a candidate. But one question we got was, will the class action cover athletes who are not national level athletes, but that still have complaints of abuse and violence from coaches? So I'm not sure if someone wants to take that.
Yep, I can take that one.
Sure, thanks, Jen.
So the answer to that is yes, it does. The proposed class definition does include athletes who weren't participating at a national level. And we mentioned this earlier, but the class definition may change either before or at the certification hearing. If that happens, then we give notice of whatever class is certified. So just to highlight, as of now, as drafted, yes, we are contemplating that we're including athletes that are not national level athletes. And we will let everyone know if our class definition gets modified.
Excellent. And then the second question was whether the class action includes homophobia or anti-LGBT, queer targeted violence, psychological, physical, and verbal abuse within the definition of abuse that we have right now.
I'm happy to answer that, Val.
Sure.
So the current definition that we're working with is, athletes that have suffered physical, sexual, psychological abuse. And so that type of abuse or treatment would fall, broadly speaking, into that type of abuse that we're pursuing.
Perfect. And then one of the other questions that we do have up on our FAQ that I wanted to bring up because it wasn't in this slide particularly is, not all of the PMOs, so the provincial member organizations, have been named. So what if someone participated in gymnastics in a province that is not specifically named as a defendant? What should those people do? I'm happy to answer that one myself, which is you should still contact us. We are still exploring, other defendants if they come to us, and it certainly doesn't prohibit you from participating in the class action as the definition is currently drafted. So if you or anyone else were involved in gymnastics in a province that's not listed, please do still contact us because we do still want to hear from you. So unless any of the other panelists have questions they think are burning, we'll let everyone get back to their Sunday afternoons. And just thank you again, everyone, for taking the time to join us. The recording will be sent out shortly, and we just thank you in advance for sharing the word. And if you need anything, you know where to find us. Okay, have a good afternoon, everyone.
Thanks, everybody.